So thank you to Julie on the first presentation and Lori and Jace. I will say as an employment lawyer, doing general work, I've actually spent probably about 50% of my time over the last year handling trade secret and confidentiality litigation, having 3 to 4 cases, on my docket at any time for all sizes of employers. So it's tremendously important what they had to say. You don't realize it until it happens. And then you have to put the genie back in the bottle. And that's not easy. We're going to shift gears a little bit with our panel this afternoon. We're going to talk about just kind of some practical things, and we're going to use recent cases over the course of last year from this area, the DMV. Many are federal cases, and we're going to use those cases to illustrate how employers have done things right and how they have done things wrong. It is our goal as counsel to keep our clients out of court. And using court cases, we can illustrate how to not end up in the same situation as those particular litigants did. Some of it has been covered a little bit in Julie's presentation in particularly, but some of this is sort of just, at the end of the day, you might say, wow, that's kind of basic housekeeping. And you're right, it is basic housekeeping, but it's amazing how often the basic housekeeping isn't taken care of. We were talking a little bit before the presentation started in the back room about your garage and your storage room and how those places become cluttered and you keep putting off handling cleaning up and doing the housekeeping. And it is those types of things that can lead clients into litigation. So these may be things that are not particularly have a big wow factor to them, but hopefully they're gentle reminders of things to take back and put on your to-do list to see if you can get to them in the near future. Or maybe it's about a policy or process that you say to yourself, yeah, we need to tweak that a little bit. I need to look at that handbook policy or process, or I need to look at my EEO process and see if I have that all buttoned up. Or maybe we need to do some training with this case illustrates. Maybe we need to do some training with certain managers to make sure they understand how to do X, Y, Z so that we don't end up in this situation. So, and then we have another case or two that illustrates some very important changes in the law that really impact the way we go about our day-to-day business so that we don't end up in litigation. So we have about a half a dozen cases, and we're just going to kind of, Mason is going to do the introduction for us. And then Matt and I are going to switch off, giving a little bit more information about the case and some takeaways, some practical information for you to leave the room with. Oh, I'm supposed to introduce myself. So my name tag, Jim Hammerschmidt. I've been doing employment law for in excess of 30 years now, and I've been privileged to be part of this firm over the last 2.5 years. And we have as you know, we have a great team here.
Mason, I don't know if my mic's on. Mason Navarrete. I've been doing just general litigation at the firm for about a year now.
And I'm Matthew Tranter. I am also a litigator at the firm. I'm a senior associate here with Clerk Early.
So let's get started. Yeah. So these first two cases are actually very, very recent, within the last month or so. And this first one, Hollis versus Morgan State, is out of the Fourth Circuit. And there, a former professor sued Morgan State under a few different actions, Title VII, Title IX, Maryland law. But the crux of her argument was that the university denied her promotions because of her sex. They paid her less than her male colleagues and retaliated against her when she complained of discrimination. Over the course of 6 years, she was denied multiple promotions. She was demoted to an at-will employee because they didn't extend her contract. And then the plaintiff's department chair had also made multiple derogatory remarks about the plaintiff's sexual orientation to other students at the university. And so the plaintiff, when she applied for these promotions, was actually voted to receive tenure by the department committee, who initially did the recommendation 2 different times. But then when that went to her department chair, recommended against the promotion. And then the president actually adopted that, which was out of practice for them. It should have actually gone to a school committee. So they kind of went, off script a little bit. But she did eventually become a tenured professor once the EEOC decided that there was reasonable cause to believe that the plaintiff was subject to discrimination. And then, so the lower court granted Morgan State summary judgment, Fourth Circuit partially reversed. And then I'll forget if Matt or Jim's taking this one away.
Yes. So why did the Fourth Circuit reverse and revive Dr. Hollis's employment-based claims? There's a few things we can learn from why the court did so. First, one of the reasons the court viewed as it was pretext, that is to say that it was not the real reason that Dr. Hollis was not promoted and that she was actually demoted. One thing that the Morgan State did is they said that she did not deserve promotion because she had 5 of her 7 articles published were either in pay-to-publish journals or journals for which she was on the board. And the court said that that type of publishing doesn't amount to warrant tenure. Unfortunately for Morgan State, there was also another professor who, like Dr. Hollis, had 2 articles published in other regular journals. And that professor was promoted while Dr. Hollis was not. And because you had what was called a comparator, that is to say, another employee in like situation who was treated differently than the plaintiff, the court said that is evidence, possible evidence of pretext for which a jury could find that the pay-to-play journal publication was not the real reason that Dr. Hollis was denied tenure and promotions. The other problem for Morgan State was that the explanations that the university gave to her over time varied quite substantially. It was the pay-to-play publishing, it was the deviations from standards, and it was a lot of other reasons. The university seemed to not have its story straight on why Dr. Hollis was treated the way she was. And so what can we learn? What we can learn is that if your company has procedures on how it deals with employees, it should follow them. I would say that, of course, make sure that those procedures are legally adequate. Inadequate procedures are not a get-out-of-jail-free card. Also, that you want to, as I mentioned, make sure that the reasons are consistent, the rationales are substantiated, and that like employees are being treated the same.
Yeah. It's important to have your documents and your story lined up. I mean, if your documents and story don't line up, that should be an immediate red flag to maybe pump the brakes on the decision-making process or reconsider it, particularly if you have an inclination that you have a litigious employee that's at issue. So those are important steps.
All right, turning to the other more recent Fourth Circuit case from August of 2025, Herkert v. Bizigano. In that case, the Social Security Administration had reassigned the plaintiff from what was a supervisory role to a non-supervisory role. They had offered her two different positions, which were, I believe, management analyst positions with the company, but she was no longer in a supervisory role. The plaintiff had initially made, a request for a reasonable accommodation, which her employer had initially allowed. But after some time, they were saying that her performance had declined. They began to deny her that reasonable accommodation for telework. And so it was after that she made that request that she was reassigned to what she described as a less desirable position. But notably, it was just kind of a one side versus the other. There was no change in pay grade, benefits, but the plaintiff, she thought that it was a less prestigious, less interesting position. She thought that she had no room for advancement with the company. And on the other side of it, the Social Security Administration said it was a lateral move because there was no change. As I mentioned, they offered her those 2 different management analyst positions. And notably, after she switched positions, she got the telework she wanted. And then the court acknowledged. So I guess the plaintiff sued under the Rehabilitation Act, alleging her reassignment was discriminatory. The court acknowledged the change in the law, and that's what Jim's going to get into.
Right. So this case illustrates the game-changing nature of a Supreme Court decision last year. And while it's under the Rehabilitation Act, and if anyone knows about that, that kind of applies to government employers. It doesn't apply to private sector. But the analysis of the Rehabilitation Act applies across the board. The courts use the same analysis, whether it's Title VII, whether it's a Section 1981 case, whether it's an ADA case, whether it's a state law discrimination case, because most states, under their laws, will look toward the federal courts for ways to analyze cases. So the fact that it's a rehabilitation case, let's not let that get in the way. But this case, so let me set the stage. We've been talking a lot about our courts, right? And in this case, we talk, okay, this is a Fourth Circuit decision. What does that mean practically for us as employers, clients, et cetera? Well, the Fourth Circuit is the federal court just below the Supreme Court. And many, many cases never get to the Supreme Court. So the Fourth Circuit is sort of the last stop for many cases. And all of the federal courts in Maryland, Virginia, North Carolina, South Carolina, and West Virginia are underneath the Fourth Circuit. So the Fourth Circuit decisions will control all the federal courts, all the trial courts in those 5 states. So this case interprets a Supreme Court case, which sets the stage for how employers and those of us in those 5 jurisdictions have to look at the law. And what do I mean by this is a game changer? So last year, a case went up to the Supreme Court called Muldrow versus the City of St. Louis. And it was about a police officer, a female police officer who had been transferred and the transfer did not affect her pay grade, did not affect her compensation, had no, what we thought was tangible benefit on her employment status. And for decades, those of us living a life in the employment law field, we're like, okay, so, no big deal. I mean, that doesn't make an adverse action for purposes of pursuing a discrimination case. If a plaintiff wants to pursue a discrimination case, they have to show that they suffered an adverse employment action. And things like this just didn't measure up in our view. It never has over the last 20 or 30 years. And the Supreme Court said, wait a second here. No. That's not the way the law is written. Title VII, if you read the statute, says nothing about whether it has to be a significant detrimental effect on the employee's status. It doesn't say it has to be a salary decrease. It doesn't have to be a decrease in the benefit or rank of that employee. What the Supreme Court said in Muldrow is that a plaintiff only need to show some disadvantage or some harm. It doesn't have to be significant. It doesn't have to be serious, and it doesn't have to be substantial. So in this case, the court looked at what the trial court did before Muldrow and said, guess what? The law has changed. We're going to apply the new law. And under the new law, Mr. Herkert, you get another shot at this. And we're going to send this back to the trial court, and we're going to vacate the summary judgment that was granted in favor of the employer. And summary judgment is what it's all about in our world. In your world, if you ever have an employment law case, because summary judgment is a place where you tell the court, hey, this case should never go to see a jury. Okay, it needs to stop now. The law's in our favor, the facts are in our favor. There's no reason for it to go to a jury. You don't, as an employer, want to have a case going before the jury, generally speaking. And that's where, as I think either Julie or Lori said, cases get settled if they're not successful in summary judgment. And in this particular instance, there were, as Mason laid out, it was an accommodation case, really. And the plaintiff, the first accommodation that was offered was she wanted to telework. She had some very serious physical disabilities and wanted to telework. And she was then being harassed for her request for telework. So one of the things the employer says, well, we'll switch you to a different supervisor or group. It won't affect your pay, but you're going to lose some of your supervisory duties and responsibilities. And she said, well, wait a second, that's not fair, right? I'm still in the same tier and I'm going to continue to be harassed by my supervisor. And, losing supervisory responsibilities, that's a tangible thing. That's prestigious for me. So they said, okay. So we're still going to move you to a non-supervisory position, but outside of the chain of command where you may be harassed. And she, quote, she said, okay, I'll accept that. At the end of the day, the court, at least on the accommodation issue, said, gee, that felt like a Hobson's choice to her. It wasn't a real choice about an accommodation. So going back to what Julie said about going through that reasonable accommodation, that interactive process is super important, because in this case, the court basically said the employer didn't go through an interactive process. They just gave her a Hobson's choice of, this bad thing or that bad thing. So what are the practical implications of Muljo and now the Fourth Circuit case? A lot of things that we did as employers with respect to employees that we thought would never give rise to a tangible adverse employment action, and therefore we wouldn't have to face a claim for, are kind of off the table now. And if anything, if an employee can figure out some harm that attaches to some employment action, it's going to get past summary judgment. So I threw up a few examples here. Putting an employee on a PIP. That was never, there's deep case law, that was never an adverse employment action. But if the employee can show that being on that PIP may affect them in some way in the future, such as not being able to be part of an opportunity for a promotion, that's going to be some harm. Removing supervisory duties, that's what this case is about, or even other material or important job duties and responsibilities. Generally, if it didn't change their rank, their pay, their benefits, the courts didn't consider it to be adverse employment action. It may well be now. Scheduling changes, that never passed muster before. But now if the employee can show maybe the scheduling change impacts maybe a single parent's ability to have childcare, or it switches their shift from a day shift to a night shift, that could be a basis for an employee to say, I've been harmed. So all of these things are now in play, and it significantly changes the playing field in terms of discrimination cases. And it's applicable. Now we have a Fourth Circuit case in couple of our jurisdictions, DC separate, that say, yes, this applies, and it's not going to apply just to a transfer situation like Muldrow. It could apply to many different types of job situations.
Shifting gears a little bit now to Hamoud versus Jimmy Seafood Inc. This is a little bit older, but still wanted to highlight it. The plaintiff was a female Muslim bartender server, and she alleged that she and her sister were subjected to religious sex-based harassment by another Muslim coworker, and that she was retaliated against after making complaints to management. And notably that this coworker and the plaintiff and her sister were the only Muslim employees at the time. And so the coworker, some of his conduct was constantly berating, yelling at, getting mad at the plaintiffs for serving alcohol, drinking alcohol after her shift, flirting with men, dressing inappropriately, reporting her dressing to other staff members, and Oftentimes they were given extra tasks, and he would stare at them angry and uncomfortably after their shifts ended, and things like that. So after all this happened, plaintiff verbally complained. She implicitly and explicitly complained to her managers, assistant managers over the course of many months, showing text messages and other things as evidence. Eventually, the plaintiff was suspended without reinstatement after making complaints to management. She sued under Title VII in Maryland Fair Employment Practices Act. She alleged that there was a hostile work environment, discrimination, and retaliation for reporting the conduct.
So why do we have this slide up, or why are we talking about this case? So this is a reminder for all of our clients and attendees to go back and take a look at their handbook and make sure that their policies and procedures for anti-harassment, discrimination, accommodations, and et cetera are up to snuff. They exist, they're well-written, and they meet the latest and greatest best practices in the employment context. This case is also illustrative. If you caught the facts, this was a Muslim worker, co-worker. That was part of the dispute, whether it was a co-worker or a supervisor, but let's call him a co-worker for the moment. It was a Muslim co-worker basically being accused of harassing another Muslim employee. So it is also a reminder that just because an alleged harasser or discriminator happened to fall in the same protected class, that is not a safe harbor. There may be an inference in those situations that it is unlikely that the person was harassing or discriminating someone in the protected class, but that inference can disappear. And in this case, the Muslim coworker had a different view of the Muslim religion than his coworkers and engaged in some really, really inappropriate behavior toward them that he did not engage in with non-Muslim coworkers. So particularly with respect to how the plaintiff and her sister dressed, he accused them of being bad Muslims or not Muslim. And they dressed in accordance with the restaurant's code, and they dressed in accordance with how their coworkers were dressing. So even though everyone involved in this litigation fell in the same protected class, it's not an escape hatch for the employer. So a couple issues here that are reminders. There are different standards of defenses if an employer is accused of having one employee harassing the other. If the alleged harasser is a supervisor, the employer company is going to be vicariously liable. That means automatically liable if the harassment is what we call quid pro quo. That is, if you don't engage in this sexual act with me, then I'm not going to promote you, give you a raise, or something like that. In those cases, there's no way out. It doesn't matter if the employer knew about it at the higher echelons or supervisors knew about it or anyone else knew about it. It just doesn't matter. And it doesn't matter what you did as an employer to rectify the situation. You're going to be stuck with it. However, if it's not quid pro quo, and in this case, it wasn't quid pro quo, the Muslim coworker was not engaging in any kind of conduct like that. But in those cases, the employer can still be liable, okay, if, oops, what happened here? There we go. If the employer knew or should have known about the coworker harassment and failed to take prompt and effective action to stop it. And that was the crux of this case. There was plenty of evidence that the female server had complained to various managers and assistant managers at the restaurant. And I love this quote, I think, in this case at one point, the court says, find it here. Oh, yeah. The court says an employer can't adopt a strategy of see no evil, hear no evil, and try to put its head in the sand when these things are happening. And in this case, there was no written complaint, and the employer didn't ask for a written complaint. So it's just a reminder that it doesn't have to be in something in writing that gives an employer or a company a responsibility to address it. It can be verbal. Okay, now we encourage our clients to have a policy that says make the written complaint and provide it to certain individuals. But just because an employee doesn't follow that doesn't mean you can say, I'm not going to address it. So employers have obligations to address verbal and written complaints in the exact same way. Now, in this case, the court looked at the policy of the company and said, yeah, it is woefully bad, basically. The company had a policy, and I'll just read it. It was a general, hey, if you have issues with your employment type of policy, it says, if there is an issue, question, or concern, please contact your manager at a convenient time to mention the issue. We do not like to make a scene in the restaurant or in front of other employees. Stay away from the grapevine effect. If there is a problem, please discuss it only to a manager. Do not discuss it with other employees before you speak with management. If there is a concern about your job, work environment, or something you like or dislike it, please voice it at our employee meetings. Yikes. They are held so we can understand everyone's viewpoints on questions or concerns you may have. Our goal is to make our restaurant a happy, positive environment. And that's it. All right, that's all they had. Hopefully, when you go back and look at your handbooks, there's a lot more there than that. But given that policy, given the failure to address the situation when it was brought up verbally, the court had no problem finding that this is a case that could and should go to a jury. They held that the policy was insufficient also, and this is the big kind of lesson learned, because it failed to place any duty on supervisors to report incidents of sexual harassment to their superiors. The court held that a jury may give negative weight to the fact that a scheme does not require a supervisor with whom complaints of sexual harassment must be lodged in the first place to forward unresolved complaints to a higher authority. This is something that I must say we don't regularly put in handbook policies that we've drafted over the years. And this is a very recent case, and it certainly is going to merit even us as lawyers looking at how we draft these policies and whether or not it has what I'll call that escalation clause, right? So now it's worthy to consider whether we add a paragraph or a sentence to our anti-harassment policies that says, you know, if a manager or a situation's not resolved, you as a manager have a duty and obligation to take that issue to a higher authority, to your manager, okay? So what are the few of the lessons, the takeaways? A, have a robust harassment, discrimination, retaliation, accommodation, EEO policy. Obviously, it was the one that the restaurant had in this case was almost a joke, and hopefully all of us are well beyond that at this point. But it does illustrate that even in the year 2025, there are employers out there who are not doing their housekeeping and not taking care of these things. We encourage the policies to identify individuals to whom issues should be reported by name, or at least by title and department, and provide the email, provide the phone number. Make it as easy as possible for your employees to bring a complaint forward. Have a hotline if you'd rather do it that way, but have a good procedure to report claims. Provide clear instructions for supervisors that they have duties to address the complaints or to escalate them. And this is the training aspect, right? We've all been kind of beat over the head in the last couple months about DEI training, but this is a little bit different. This is about training your managers and supervisors how to handle these claims so that they don't end up swept under the rug. And act on verbal complaints as well as written complaints. The other thing is promptly investigate complaints of harassment, discrimination, and failure to accommodate. And I think, Matt, you have maybe a case talks a little bit about that. Yeah, the next one. And then and take prompt and effective correction action after that investigation reveals whether or not something inappropriate happened.
All right, turning to the next case, Jackson v. Collins, also within the last month, pretty recent case. In that case, the plaintiff had complained of inappropriate behavior by a coworker who was romantically interested in plaintiff. I guess to give a little background context, he had asked her to kiss him, had rubbed her arm, asked them to move to like cities together, and all over the course of 1 week. And so plaintiff had alleged that she complained of all of these specific instances to her supervisor. The supervisor responded by directing the coworker to not have contact with plaintiff, and initiated immediate fact-finding and elevated these concerns to his own superiors. The coworker continued to approach the plaintiff even after that no contact was ordered. Plaintiff complained of the slow pace of the investigation, and because of that, she initiated I guess investigation to the Veterans Administration Police. But ultimately, the investigation concluded that the harassment allegations were not sustained, as plaintiff never verbalized to the coworker themselves that the comments were unwelcome and unwanted. The employer also instructed the coworker not to have contact with the plaintiff, and the coworker complete sexual harassment training, which the coworker eventually did complete. And then plaintiff sued under Title VII, alleging a hostile work environment.
Thanks, Mason. And one thing to add there. So when Jackson complained to her superior, the superior ran up the flagpole immediately. As Mason mentioned, gave the no contact order between Ms. Jackson and the harassing coworker. Ms. Jackson's supervisor also started an investigation, but was unable to get an adequate investigator for several weeks after the initial complaint. And Ms. Jackson said that that was too slow. But what can we learn from Jackson v. Collins is that, and why did the Jackson v. Collins employer win while the Hammoud employer lose? And it's because in Hammoud, we have see no evil, hear no evil is insufficient. In Jackson, perfection is not the enemy of good. The Jackson employer responded immediately. They gave the no contact order. They started the investigatory process that was delayed while they were finding an appropriate investigator. So they did essentially what they could do immediately, and they put the process into motion. And that is that do what you can, get things started, get going, but if there's a minor slip up or a slight delay, that doesn't mean that you'll still have to see a jury at the end of the case. That can still result in the employer succeeding through a summary judgment motion. That one's easy.
Okay. We obviously purposely did those. We purposely did those cases back to back. One illustrates complete failure and the other illustrates success. And I think it's really important what Matt said, that don't let the perfect be the enemy of the good, right? Significant ways to address coworker harassment when it comes to you, right? Separate the employees. And by the way, don't make the person who's bringing the complaint the one to suffer from that separation, right? If someone needs to be on leave, it's better to put the alleged harasser on leave than it is to put the one who is being harassed on leave. I'll take that case any day. I'll take a situation where the alleged harasser tries to turn the tables and allege that he or she was discriminated against because he or she was put on leave while the investigation proceeded. I'm happy to defend that situation. So it's really important to think about when a complaint comes in, what are our options to stop this, or at least put everybody in a more comfortable position while we try to figure it out. And there are three options for handling complaints. The first is to do the investigation internally by yourself as the employer. That has certain obviously cost advantages. It's much less costly to do that investigation internally. But you need to consider whether or not you have the appropriate skill set in place to do it. Because if the case goes to a trial, for example, or gets litigated, and the question is whether you took a prompt and effective measures to address the complaint in the situation, whoever did that investigation is going to get deposed. They're going to be put on a hot seat. And the questions are going to be asked, like, how many times have you done an investigation? What training do you have? Have you ever been certified to do an investigation? Are you familiar with the best practices of conducting an investigation? So if you're going to conduct an investigation internally, be prepared to think about those questions and make sure you're going to feel comfortable how they are answered in a deposition. The second option is to perhaps have your attorneys do an investigation. The benefit there is the attorneys are generally familiar with your business, maybe even the various employees in the business, and you're comfortable generally with their advice and counsel. Again, that's, and maybe they don't have as steep a learning curve and therefore it's more cost efficient. And that can work, but again, there are issues that can arise such as, will we want to use that investigation to defend ourselves, to show that we in fact took prompt and corrective action in response to this complaint? If that is the case, there's no attorney-client privilege that's going to protect what your attorney did and the communications your attorney had with you. So you have to be prepared to live with the fact that all of those communications and your attorney-client privilege is not going to be able to use as a defense. You're not going to be able to keep the privilege and use the investigation as a defense. So the third option we turn to, and we've done all three of these, is we will hire an outside third party to do an investigation, typically maybe an employment lawyer at another firm, or there are outside services, employment practice solutions down in Texas. I've used them quite often. In fact, I have a situation like that right now where I'm using another firm to conduct an investigation because the client wants to retain our ability, Lord Jurley's ability to litigate that case if it goes further. And so we can keep all of my communications with the client privileged. So I'm getting information from the investigator, but how I communicate that to my client is privileged. And any feedback I'm getting from my client is privileged. So those three options are very useful to think about when a complaint comes forward. How are we going to deal with this? Right? Are we going to do it ourselves? Should we have our attorneys do it? Should we listen to our attorneys and have an outside party do it? Obviously, the last one is the most the most expensive, often.
All right, turning to the next case, Samira versus District Smiles out of the District Court of Maryland. It jumped around a little bit, but it ended up in the District Court of Maryland. And that was where a Muslim Arab male dentist alleged that he experienced discrimination based on his race, religion, and gender. He alleged that he was called the N-word by his coworker, discriminated against for having a long beard, that he was called a terrorist by a coworker, and that 1 month after he complained about these issues, he was fired. And after this, he said that all of this was done in retaliation, essentially. And so the employer presented evidence that prior to his termination, he violated the employment contract that specified, what he could and couldn't do, and that he had engaged in specific misconduct. And that specific misconduct was that he failed to notify the employer that he was running for state office and conducted campaign-related work inside the office. He was tardy for patient appointments routinely. He failed to take intraoral photos of patients on every patient as required. And he even failed to to follow this procedure even after he was notified that he had to do it. And then he slept in the office when he didn't have patients, including falling asleep in the waiting room, where other people could see. And so kind of the final straw was the employer fired the plaintiff after he locked himself in a patient room and began copying patient information from the computer with the patient in the chair. And the court was here deciding, whether or not to grant summary judgment, which Jim will talk about more.
Right, thank you. So one of my often comments to clients is don't win the battle and lose the war. And what do I mean by that? If you got everything going good in terms of how you're handling a discrimination complaint, or there's just not enough evidence there to make a valid complaint, but then you fire the employee shortly after the complaint's brought, even if it's bogus, you're going to lose the war, because a retaliation, what the EOC hates more than underlying discrimination claims is retaliation claims. They want to protect the employee's right to complain. So on the facts of this case, you think, holy cow, whoops, right? I mean, lots of bad stuff going on. And 1 month after complaint, he's fired. And we brought this case to give you some hope that even though you may have a retaliation situation, there is still an escape hatch if you have the right facts and this is what it's all about, and you've documented it, right? So what happens in the way the courts look at retaliation cases is they basically say, gee, if there's a close proximity between the complaint and the adverse employment action, that's pretty much a sure thing we're going to let go to a jury. We're going to let the jury decide whether or not those two events are causally related. They're connected. So in a lot of cases, employers get stuff. Employees are smart these days. They're really smart. They're good at searching the internet. And they figured out how they can put a prophylactic bubble wrap around themselves. If they're performing poorly, they're doing bad stuff, they know they're on the hot seat. Gee, if I just complain about something, I'm going to be protected. In this case says, yeah, maybe, but you know what? If we've done our job as an employer and we've documented all the poor performance and misconduct that you engaged in, the court's going to end up favoring in our favor, even if there's that close temporal proximity between the two events. And so, for example, in this case, what the court said is that Samira, the dentist, demonstrated sufficient causal relationship between the two purposes, that is the complaint and the adverse employment action, to meet his prima facie case. That means now, employer, you are on the hot seat. Tell us why we shouldn't have this case go forward. And the court went on to find that because the burden now shifts to the employer to present a legitimate non-discriminatory reason. And the defendants offered several legitimate reasons for Samira's termination. And here's the key: supported by record evidence. This employer had done a great job of documenting the falling asleep, the tardiness, the fact that he was violating his contract by engaging in other activities while he was there on work purposes, stealing the client's, the practices, customer list, ding, 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 back to Jason Laurie, right? And they had protected that customer list also. They had taken steps to keep it confidential. Only certain people had access to it. He had access, but he's sitting there with a patient in the chair and he's downloading all this stuff because he knows he's in trouble, and he's locked the door so no one can stop it. Right? So all of these things were well documented. So the takeaway here is take the time to do the hard management work to document poor performance and misconduct. It doesn't always have to be a lot. It can be a memo to file. It can be a quick email to yourself, right? How long does it take us with, Grammarly and Voice? You can knock out an email in 2 seconds. Make sure it's dated. Create the document contemporaneously with the events. Be specific about what occurred. Send an email to the employees so they have notice. So there's documented that you put the employee on notice. These are all critical documentation steps that can help you when there's a really difficult, natty, tough situation that you need to deal with, because no one wants this employee to continue to hang around after they've done all this bad stuff. But when they've just complained, that makes all of us in the employment law group at Lord Shirley uncomfortable. So if you come to me and say, but Jim, we have all of this stuff documented, I'm like, all right, let's talk. This conversation is going to go a little bit differently.
All right, our final case of the day, Ames versus Ohio Department of Youth Services. This is a United States Supreme Court decision that was released in June. To give a little context, the plaintiff was working for a juvenile correctional system out of Ohio. She was a heterosexual white woman who sued under Title VII, alleging that her employer discriminated against her when first it hired a lesbian woman for a new management position instead of her, and then subsequently, she was demoted and her position was given to a gay man. And so the company had initially interviewed plaintiff for the position, but removed her from her current role and demoted her to a secretarial role just a few days after her interview. And so the issue really turned on whether the majority group plaintiffs have a heightened evidentiary burden in discrimination cases compared to minority group plaintiffs, because she was part of a majority group as a heterosexual white woman. The district court had granted summary judgment to the agency, finding that the plaintiff had not shown that the agency was a, quote, rare employer who discriminates against members of a majority group. The Sixth Circuit affirmed that decision, stating that as a straight woman, she was required to make a showing that in addition to the usual ones for establishing a prima facie case. And so, yeah, the court wrestled with this. They called it an inflexible formulation of the standard, which Matt's going to get more into.
Thanks, Mason. So when Jim was just talking about that District Smiles case, what he was referencing in that multi-stage process, that 3-stage process, is what's called the McDonnell-Douglas framework for evaluating Title VII actions. And as Mason mentioned, a lot of courts until Ames said that majority group plaintiffs, so this being a straight woman, had to show more than a minority group plaintiff in order to prevail. Ames says no more. Every plaintiff has to make the exact same showing, that McDonnell-Douglas 3-step showing, in order to be able to get to a jury. But what does this case mean? This case means that essentially there may be an uptick of majority group discrimination actions brought against employers across the entire country. It also somewhat reflects the current administration's regulatory climate and its anti-DEI posture that it's been taking. For employers, one thing that is important to keep in mind is that, what the prior administration may have celebrated, the current administration may punish. Also, obviously treat all employees the same regardless of any of their statuses. And lastly, take a look at the policies that were celebrated a few years ago, because certain people may try to misconstrue or turn those against you offensively in a later discrimination suit. Make sure that they are open to all employees, regardless of any protected status. But besides that, anything to add, Jim?
No, in this case is pretty straightforward. And frankly, if you take the time to look at the statute, look at Title VII, nowhere in there does it suggest that someone in the majority or otherwise is subject to a heightened standard. I mean, it's kind of a no-brainer decision, and it was unanimous in the sense. There was some dissent about the standard being used because, yeah, the concurrence. I'm sorry. Yeah, there was some language in the concurrence because one of the justices doesn't particularly like this burden shifting McDonnell Douglas thing and thinks it ought to just go away, and took the opportunity of this case to discuss it. But generally speaking, it was a unanimous decision and makes sense. Scott, how much time do we have? We're there? All right. Any questions? All right. Thank you for your attention.